All right, I think I'm live. Hey there, guys. Come on in. Come on in. Let's get going. We're going to have our live Q&A, an immigration show today. It's July 4th. Come on in and say freedom now, freedom now. Join me today as I get myself all set up here on McBean Immigration TV to do this with you today. Happy 4th, friends. Happy 4th. Freedom now, freedom now. Come on in. And let me know who is watching and where you're watching from, and certainly how you're feeling today. Okay? Come on in. Freedom now. Thank you so much for being with me. All right. Freedom now. Freedom now. Happy 4th of July. Guys, I wanted to come in and catch you before your festivities begin for July 4th. Okay, I see that folks are live now. Hey there, just come on in. Freedom Now from Texas. Thank you. Texas is in the house. Hey there, Fernando from San Jose, California. Come on in. Freedom Now, Freedom Now. Let's go. Yes, guys. Let me know how you're feeling. Okay, let me know how you're feeling. I told you earlier this week when I was on live with you on Monday on McBean Immigration TV that I would be back before you sometime this week to continue our Q&A session. Hey there, Maureen from Newark, New Jersey. Freedom Now, Nella. Good to see you. I see that Las Vegas is in the house. Connecticut, Valentina, thank you for being with me. Dean is here also from Illinois. Freedom Now, Freedom Now. Angel, Freedom Now. Kareen from New Jersey, good to see you. Hey there, Saeed. Thanks for being with me. Guys, thank you for your faithfulness, okay? Thank you for being faithful. We're going to have our immigration Q&A session today and just connect, okay? We're going to connect. Let me know how you guys are feeling today. Happy 4th. I see that Brooklyn is also in the house. How are you guys feeling today? Are you feeling terrific? Are you feeling a little anxious? Are you feeling let me know how you're feeling, okay? I know that some news came out quite recently from the Supreme Court. We'll talk about more of those issues tomorrow during our Q&A, our news broadcast, our Friday Immigration News Roundup. We'll talk about the Supreme Court decisions, and I know that some people are feeling very anxious as a result of the decisions that came out recently. Freedom Now, happy 4th. Freedom Now, Freedom Now. Excellent. Thank you guys for being here. Happy 4th. Hey there, Charmaine from Albany. I'm Latoya McBean Pompey. I'm an immigration lawyer in New York, and I work with clients globally at McBean Law. We work with individuals who have been in the United States for a very long time, who did not um, who have problems becoming lawful here in the US. We also help individuals who are outside of the United States trying to get in, and they have problems getting in. That's who we are. We're all about freedom. So that's why I'm asking that you guys type in freedom now, freedom now, freedom now, so that you can connect with me and connect with others around the globe who are feeling this sense of wanting this freedom that for some people, immigration brings that freedom. Okay, so type in freedom now. Beverly, good to see you from Massachusetts. It's hot here in New York. There's a heat wave across the entire US. Also, we're praying for countries like Jamaica. I'm from Jamaica. I'm Jamaican born, where they are also facing some um, uh, devastating issues with regard to a hurricane. So we're praying for the Caribbean islands, Jamaica in particular. Freedom now. Or any Jamaicans in the house? If you're from Jamaica, just let me know. Let me see some flags. Let me see some flags. I see that Dubai is in the house. Awesome. Very nice. Thank you, Carl, for being with me this afternoon. Let's just spend some time together, guys. Let's talk some immigration. All right, let's talk immigration. What's on your mind today? We're going to, happy 4th, Deborah. We're going to go into your immigration questions this afternoon. So now let's see. The first question comes from Deidre, who says that if Trump wins the presidency, what will happen to asylum cases that are waiting for approval? Great question, Deidre. So what we can do is we could look to how things were during his first administration to, okay, I see all of the Yardies are in the house. I'm seeing tons of flags here. All right. So as I answer this question, I'm just going to show some of my fellow Jamaicans who are in the house, some Yardi folks. Okay. So with Trump, if Trump comes back, let's look back at his first administration and what he did with asylum. Yes, they turned up asylum upside down, particularly for those who have been in the United States, wait in for an asylum interview. Folks ended up waiting longer. Some people were put to the back of the line, right? It was really crazy and awful for a lot of people who had their asylum cases pending. So they made the asylum process more difficult for those who are seeking affirmative asylum in the United States. But then at the same time, they tried to expedite cases, newly filed asylum cases. They were quickly trying to get these people in removal proceedings. Okay, so I think that if he does comes back, of course, we're expecting him to again attack those who are seeking asylum, those who have a good claim to asylum. You should not fear too much because your case will still go through the process of being evaluated objectively by an officer at USCIS who is not a political appointee. Okay, these are real people who have guidelines about what they should follow, what they should look for when they're evaluating an asylum case. If your case is in immigration court, the judge is going to make the decision. It depends certainly on the merit of your case. So let's just continue to um, be hopeful. And if you have a good asylum case, great. You have nothing really to worry that much about. But if your case doesn't have any merit, whether Trump is in office or not, it won't be approved. Okay, freedom now, freedom now. For those who have been here for over 20 years, they pay taxes as well. Yes, yes, many of them do pay taxes. Freedom now. Now let's see. Equity Justice says, will Congress ever update the immigration registry date? I'm disappointed in the Democratic Party. They deliberately ignore immigrants and only throw scraps when elections come around. Absolutely, I completely agree with that. Equity Justice, in my opinion, they had a great opportunity a couple of years ago to do something incredibly meaningful around immigration when we were all talking about reconciliation and there was so much momentum, so many chances that they had to do something, but they punted and they were hypocritical. They were hypocritical, okay? They were hypocritical with how they approached immigration, and they really disappointed a lot of people. Elections do matter, of course, but speak locally to those who are within your reach, your local congressmen and women, about how you really feel about immigration. Let them hear your voices. If you're connected to a U.S. citizen, have that U.S. citizen individual also advocate on your behalf. But it's disappointing. Congress is really not performing in the way that any of us would like to see them perform. I don't have any updates about. Uh, I haven't actually studied the visa bulletin, the latest visa bulletin yet, guys, which is why you haven't heard me talk about it. I've just been so caught up with the Biden parole in place and helping people to understand what's going on there. But check the latest visa bulletin for anything related to the July bulletin for updates about your categories for those of you who are waiting. Freedom now, freedom now. Someone says, MJ says, um, I'm happy because the USCIS received the I-130. Your office sent for my case. Okay, so MJ client. All right, thank you very much for your help. Hope everything goes well. God bless you. Well, thank you for that, MJ. We're standing with you. As you know how we are at McBean Law. We are obsessed with results. We are results driven. We are results driven. Let's see. Freedom Now. Freedom Now. Come on in, guys. Let's just hang out for a little bit on this July 4th together. Freedom Now. Now, Skeeter says, I just mailed. Let me just do this, Skeeter. Give me a second, guys. Let me try to fix something on my end that you guys. Okay. So Skeeter says, I mailed my son's I-130 but I didn't know that I was supposed to put the fee in the package. How can I pay? So, Skeeter, if you USCIS will reject that filing, they'll send it back to you, okay? That will be sent back to you, and then you'll have an opportunity to include your money order or your check with the refiling of your case. So, not to worry, you could still rectify this and get the case filed, but they will send your package back to you. Thank you so much for that question. Thank you. Deborah is asking, after applying for children who are outside of the US, how long does it take to schedule an interview? Now, Deborah, how long it takes to schedule an interview, of course, will depend, as you hear me and other immigration lawyers on TikTok and YouTube say all the time, that it depends on the embassy, okay? The embassy that is going to be reviewing your case for your children and what their backlog or case load is like. So it truly depends. And also, if your children are immediate relatives of is an immediate relative of a U.S. citizen parent. I'm not sure if this is a green card holder parent or whether this is a U.S. citizen parent, but immigrant relative cases tend to go faster, certainly at the USCIS level. But if your embassy is slow to process the cases, like some embassies like Accra, Ghana, even immediate relative cases can be pending for more than a year or up to 2 years, as far as what we've seen by some embassies. So it really will depend. Thank you for that question. I know that when you file for your child or your children abroad, you're always very anxious about how long it will take to bring them here because, of course, the school year and then some other logistics with who's taking care of them abroad, and obviously some very personal issues involving the children and what they're going through due to the separation. It's very hard to be separated when you're a child, separated from your parent. So I know parents are often very, very anxious. That is why it's so important to make sure your case is done correctly in the beginning so as to avoid the delays that comes with not filing correctly, like the question that I answered earlier about filing the I-130 for the son but didn't include the fee. Well, guess what? That case is going to be delayed because of that error. Or it could be errors involving how you prepared your case too if you're doing this on your own. So although some cases seem very easy to process, but like bringing a child here to the United States, very straightforward process. If you don't really know what you're doing, it could really slow down your case. So be careful with that, parents, and make sure you get your cases done correctly, okay? So that your children can be with you sooner rather than later. Swen is asking, if someone is in removal proceedings, can they file for a national interest waiver if they are here and they have an advanced degree? That's a great question, Swen. So if you're in removal proceedings and you're now trying to do an employment-based process, whether it's the NIW or whether you have an employer who wants to file for you, one thing you have to consider is that, well, how in the world are you going to get your green card in your hands? At the end of the day, let's cut to the chase. I want that green card in my hand. Well, to get the green card in your hand, the government will specifically be looking at your immigration record to determine whether you had continuously maintained a lawful status in the United States from start until finish, right? Finish being when they're looking at your case and you're before them if they called you in for an interview. So if you had not continuously maintained a lawful status, you will not be able to get the green card here on US soil. The process would require you to file a waiver, and then after that waiver is approved, go back home for an embassy interview. That's the process. So with you being in removal, there's some things there on your immigration record, I'm certain that would interfere with the opportunity to apply for the national interest waiver and get the green card here on US soil. It's not impossible. It's possible if you have what you need. You'll need a certain relative for the waiver. If you have that relative for the waiver, it's possible, and we could walk you through each and every step from getting out of removal to completing the employment-based process successfully at the end of the day. But it's the visa overstay people, and then the people who are in immigration court proceedings, or those who have a removal order, they encounter this problem of being very qualified for an employment-based process, but they cannot successfully get the green card here in the US. They would need to get a waiver and go back home. So, Anne, if you'd like to go deeper about that, book a consultation with our firm. Our contact details, friends, are the contact details for our office is scrolling below. Email us at info@mcbeanlaw.com to speak with someone on my team about booking a consultation. Call us at 888-462-4006. You could even book an appointment today, as a matter of fact, because our receptionists are standing by until I think 6 o'clock or 5 o'clock Eastern time today to book your appointments. So give our office a call today to book an appointment, 888-462-4006. Is there any hope for people who have been in the United States for more than 10 years? Absolutely, there is hope for people who have been here more than 10 years. You could go to our website at mcbeanlaw.com/success and see how we've helped people who have been here 20 years, 30 years, 40 years. Every single person will need to fit into a bucket that Congress created for the pathway to the green card. If you're able to fit into that bucket, excellent. Whether you're here 10 years or 5 years, you'll get the green card. Now, for those who have been watching and waiting for the opportunity related to something I've mentioned, actually, I mentioned this a couple of times because I'm actually watching this opportunity as well. In September of last year, the Biden administration moved the needle with respect to those of you who have been here at least 10 years, who have a certain US citizen or green card holder relative, and maybe you've been a caregiver because this person has been sick, or or this child has very significant issues. They are trying to open the door to allow you to apply for cancellation of removal for the 10-year green card, despite the fact that you're not yet in removal proceedings. Cancellation of removal only helps those today who are in immigration court removal proceedings. The Biden administration started the process of opening this door to others who fit the rest of the criteria for you guys to be able to get your green card, and you're not even in removal proceedings yet. I'm watching that. They haven't really, that it's not in effect yet, but they did something last September to put this on the table, on the agenda, to move this forward. And there's advocacy in Washington, D.C. by certain groups to really, nudge them. Okay. So that's what I'm watching for those who have been here for at least 10 years. Okay. Freedom now, freedom now. If you guys are enjoying this, give me some, say I'm enjoying this. Let's just say I'm enjoying this. Okay. Say I'm enjoying this. Thank you, freedom now. Freedom now. Charlotte says, and this is a Jamaican, my Jamaican countrywoman. She says, I filed for my husband since 2020. He's in Jamaica. She's a US citizen. And 3 months ago, they said 3 months ago that I would hear from them by now. And then it went back up to 3 months. Now it says 4 weeks. Is there any hope? So, Charlotte, where are you seeing the pushback, right, with the time, right, the 3 months? Who is it at the USCIS level that your I-130 hasn't been approved yet? Because that seems really off in terms of the processing times. It should have, if it's the I-130 that hasn't been approved yet, and USCIS, the updates have been, okay, and give it another 3 months or another 4 weeks. Well, something is wrong there. Your case, that I-130 should have been approved years ago. If your husband's case went all the way up to the US Embassy level and he was interviewed and then they placed him in administrative processing and then they're pushing back and delaying things, we could jump in there as well. So reach out to our office at 888-462-4006 to book an appointment with us, all right? France says that if Trump wins, a lot of immigration people will suffer. Yes, it's going to be a problem for a lot of people. Freedom now, freedom now. Thank you. Thank you. Carl says, I'm marrying my fiance in her country in the Dominican Republic, DR. Is it true the Supreme Court ruled against bringing your spouse to the U.S. To the U.S.? So Carl is asking whether the recent U.S. Supreme Court ruling prevents U.S. citizens from bringing their spouse to the United States. No, that is not what that ruling says. That is not what it means. You have a fundamental right under our Constitution to get married. That's been on the books. Fundamental right to marry whoever you want to. What the US Supreme Court has recently said is that, well, you do not have a right, fundamental right, to bring that spouse here and live in the US with that spouse. If our INA and our immigration laws says that, well, if your spouse is committed an aggravated felony and he or she was deported from the United States, well, they're not going to come back through the green card process, regardless if they're married to a US citizen or not. Or if that spouse in the DR committed some very serious crimes there in the DR, and the US Embassy says, wait a minute, this person is barred from getting a green card under our system, our laws, that person is just barred, period. There is no fundamental right to bring that person here. So the fact that you're married, your foreigner spouse is married to a US citizen doesn't mean that that spouse is gonna override US immigration laws and rules and say and come here to be with you. That's essentially what that Supreme Court ruling says. You can still absolutely file for your spouse today and bring your spouse to America. Okay, you can do that. But if that spouse has immigration problems, immigration history that is very damaging, well, that person will need a lawyer to analyze what those problems are and whether they can come in through the green card process or not. If the person cannot enter through a green card process, the lawyer or we would tell you, well, you could bring this person here under a visa, a different type of visa, okay? But that person will need a waiver. So bring your spouse here. I don't like the fiance process, by the way, guys. I never talk about it because I think it's just a flawed process and it could really delay cases. If if you do that K1 fiance visa, and it does work for a lot of people that I know, but people who come to see us, they have problems on their record. So the fiance visa process inevitably slows down their process of bringing the spouse here. Plus, it's a lengthy and expensive process as well. So marriage cases is a better way to go for many people. So I'm glad to know that Carl is going to pursue a marriage filing. Freedom now, freedom now, freedom now, freedom now, freedom now. Deborah is asking, how can one pay taxes at a new job who's not offering the W-2 form for taxes? Deborah, that's something that you're going to have to work out with your employer, because you're supposed to. An employer who's on the up and up has to follow certain protocols, like giving you an I-9 form to fill out, right? Putting you on payroll, having an employee file just in case there's an audit or something. They're ready to go, and so your HR should be following those protocols. Okay, freedom now, friends. My Marnus says, my wife filed my I-130 through consular processing. She's a US citizen. If I enter the US on my tourist visa, can I change my status from inside of the US? Thank you for that question. So the question is, well, his spouse has filed for him and she's a US citizen. He's outside of the country. If he comes to the US on his tourist visa, can he change his case to adjustment of status? This is a delicate issue. The short answer is yes. But you have to pay attention to the timing because you can't come to the United States with that tourist visa just with the intent to adjust your status and get your green card here, because that's an inconsistent use of that tourist visa. So if you were to have that kind of mindset and then you made that transition, and filed your case really soon after coming, that could be an issue for you. That could be a little stumbling block in your case. But absolutely, after some time, you can transition and just do adjustment of status after some time. So you could speak more with us if you'd like to address the concerns that we normally share with people about that type of process. But yes, it can be done. Will the new will the new president Will the new president, what new president? We have a new president that I'm unaware of. Has things happened already, Dean or Denny? Will the new president affect the process of T visa seekers? No, nothing is on the table currently that I'm aware of that will impact T visa seekers, trafficking victims. Congress has already laid out the number of visas that are available each year for trafficking victims. We never reach that amount. USCIS never reaches that amount of applications for individuals who are qualified for the T visa. To my knowledge, there aren't any changes on the table that I've seen related to victim cases, whether it's the U visa for crime victims or T visa for trafficking victims or domestic violence victims, VAWA. I haven't seen any proposals that would hurt those processes. Okay, thank you. Someone says my husband's I-130 has been approved a year ago and we're still waiting. We're still waiting on the priority date. Okay. So, by the way, what you should know, friends, is that if your spouse is a green card holder and they filed for you, you will have to wait for your priority date to be current in order to move forward with the next step in the process. And the next step in the process truly is uh, the visa center process if you're overseas, or if you're here in the United States, the next step would be adjustment of status, but you cannot do the adjustment of status if if you had gone out of status prior to filing your case. But it's a little bit more than that. I'm not going to get into all of those details now. Let's go through all the questions. If you have questions related to how can you get a green card, if your spouse is a green card holder, book a consultation so that we could talk with you about that process. Thank you. Kwame says, can I renew? Kwame had TPS from the Ebola days, right, in Sierra Leone, and TPS is no longer available for that country. And he's asking whether he can renew his work authorization. You could only renew a work authorization under TPS if that country is currently still designated as a TPS country. So, no, you won't be able to do that. When can we apply for the PIP? At the end of the summer, which could be in August or September, when they open up the application process. No, we don't have the date yet. Hey, Charla from Jamaica answered one of your questions earlier, I think. At the end of the summer. Dwight is asking, good afternoon. I did my marriage case petition in October 2023. So far, I've gotten my work permit and my social security card, but no green card. Do you think there's an issue about why I haven't received anything else yet? You're in good shape. You're still in good shape, although you will hear me talk a lot in videos about the fact that the processing times have increased for cases that were filed, marriage cases that have been filed since January of this year. We've seen a very fast processing cycle for them, 3 months, 4 months for adjustment of status. For those that were filed in 2023, you will still be waiting. It's so strange, so weird what USCIS does internally. I don't know. I can't explain why they're processing cases that have been recently filed this year faster than those last year. It's weird. But you're still in good shape. October 2023, you're not even at a year yet, right, of the case being filed. So hang in there and you'll get your green card, okay? And if you run into any problems with getting the green card, like a request for evidence or an interview and it didn't go well and a notice of intent to deny, we'd be so happy to work with you on those those issues. Freedom Now. Dwight said that they didn't use a lawyer for their filing. Okay, okay. If you need any help with your case, Dwight, let us know. We'd be happy to meet with you. Freedom Now. I think everybody should file before Trump comes back. Jada, I think that now is the time, as I've been saying since last year. Now is the time. Now is the time. Cannot emphasize that enough. I hope you feel that within your spirit. Now is the time to do your immigration case. Whether Trump comes back or not, now is still the time, okay? Is there any hope for anyone who has been here for more than 25 years, US citizen, has a US citizen son, but entered without inspection? Katie is asking. Here, you're here in the United States for many years, more than 25 years, and you have a qualified US citizen adult son who could file for you, but you entered without inspection. The problem that you're facing is the entering without inspection part. And you have a pathway to a green card. You know, you still have a pathway to a green card. However, you'll have to get your green card process finished at the US Embassy in your home country. If you're able to meet the requirements that's necessary to finish the process at a US Embassy, you can definitely get your green card. And this is precisely what the Biden administration has done recently for spouses of US citizens in this context, in this situation. But they didn't extend it for parents, which is so bizarre. They really should have done the same for parents of U.S. citizens. Thank you, Freedom Now. Now let's see, Freedom Now. Um, what's next after the prima facie, and what this is under VAWA, Violence Against Women Act, a domestic violence case. What RFE, usually USCIS, issues based on VAWA? What RFE does USCIS issue after you filed your VAWA case? So the RFE could be related to showing evidence that you were in fact married to a US citizen or a green card holder. So some RFEs do call into question whether you were legally, legitimately married to that spouse, number one. The second type of RFE issue is usually about evidence to prove that you were abused in this marriage. If you could prove that you were abused in this marriage, then you've got it. Some other RFEs target whether you guys had ever lived together. Okay, because that's a requirement too under VAWA. Not that you needed to have lived with this abuser spouse for years or anything like that. No, it doesn't require that. But you have to show some proof that you guys shared a residence together, however brief it was. Those are typically, and then the fourth issue, RFE issue that we see for some of our clients who come to us to help them with the RFE is related to whether they had properly divorced from their spouse back in their home country. Typically, we see the divorce issue come up with countries like Nigeria. Sometimes it comes up with countries like Philippines as well, but primarily Nigeria. Sometimes Ghana. Very rarely do we see it from Ghana. But when we see it, when they come to us with that problem, we recognize it and we know how to help the client fix the situation if it's fixable. Okay, so those are the top issues that are usually asked about during the RFE process in VAWA cases. Freedom Now. Someone beloved says, I have filed the I-601A a couple of months ago, which is the unlawful presence waiver, but I'm skeptical about the backlog. Do you think the new fees will bring a little hope? The I-601A is taken 3 to 4 years to process. The fee increase has gone into effect. It's only been in effect since April 1st. Can I say that we've seen how the fee increase has helped push the needle to open the door for an approval for the I-601A faster for people? No, we haven't seen that. We do know that there is litigation and pending, and we think that the litigation is actually what's happening now to allow some of our 2020 and 2021 601As to be approved, because all of a sudden we got a lot of our 601As from 2020 approved all around the same time. So the fee increase, I have not seen how it's helping 601A. The fee increase, we think it's helping, potentially, it's helping with the marriage cases because they're being approved faster this year. So that's what we're seeing. Thank you for that question. Freedom Now, Freedom Now. Gordon is asking, he says, I've been here for 5 years. I came here legally, but I've overstayed. I would like to obtain citizenship. What's the best way to go about getting my foot in the door? So, what Gordon is actually talking about here is not citizenship, it's green card residency, because he's talking about getting his foot in the door. Okay. So, Gordon, we would look to see, or Godin, I'm sorry, Godin, we would look to see, hey there, Juliet. Happy 4th, everyone. Godin, we would be looking to see whether you have a relative that could make you eligible for a green card, or well, you've overstayed, so the employment process isn't going to help you on U.S. soil, not unless you have a parent or a spouse who's a U.S. citizen or a green card holder who you could get a waiver through and go back home. That's possible. Maybe, Godin, if you have a humanitarian issue that opens the door for you. If you've been a victim of a crime here in the United States, that could open the door for you. If you had, and speaking of crimes, just so you know, we had a U visa case, a crime victims case recently. I don't know if we testified about this one, in which the client had been flashed by someone on the street. Those people who do those kinds of things, right? They flash people. And so the client, what made the difference in this case is that you might be saying, well, that's not a big issue. That's not anything that could open the door for a green card. But yes, it is, because in her case, she went to the police and she complained that this guy on the street flashed me today. And the cops actually took that seriously and they actually arrested the guy. His name is now on a sex offender list. And the police department they were quick to approve the certification of her U visa case. And so that opened the door to a pathway to legal status for her through USCIS. If they approve her case, it takes about 5 years for USCIS to approve the case. But in the meantime, she'll be able to get a work permit while she waits on her U visa case to be completely reviewed by USCIS. So if you've been a victim of a crime here in the United States, just know that you should speak with an immigration lawyer to talk about what happened so that we could evaluate whether you're eligible for the U visa pathway to lawful status. Freedom Now, Freedom Now. Nikki says that I've been here for 11 years. By the way, if I answer your question and I'm trying to take it one by one, just give me some hearts and just say freedom now or thank you. Just, I want the engagement today. Interact with me. Freedom Now, I've been here for 11 years and my charge was a felony. I took voluntary deportation. I'm married in New York City since 2006. How can my husband help me? So, Nikki, it sounds like you're still here in the United States, right? Although you said that you were in removal proceedings and you took voluntary deportation, which is voluntary departure, which says that you were supposed to leave the United States by a certain date, but you have a felony, an old felony from 11 years ago that sounds like perhaps that's what got you into removal proceedings. So it's a serious issue, the felony. Your case what we would do in a situation like this is We would want to know what the felony was. We would look at your immigration history as well, get your records from the government, look at your criminal records as well. And then we would have to see whether you had committed, whether this is, I don't think this would be an aggravated felony, because if it was, you most likely they would have deported you rather than, giving you this voluntary departure. So we would look at your crime to see what exactly it is, and whether it's possible for you to overcome through a waiver process through your husband. But we would be working at looking at the immigration track as well as a USCIS track if you have one. You may have a USCIS I-130 track through your husband, but certainly with your voluntary departure converted into a removal order, since you didn't leave the US if you're still here, then that case will need to be reopened. And the reopening of that case really will depend on what that felony is, okay? So contact us. Love to talk with you more about this. This is what we do at McBean Law. Would love to talk with you about this. And I have a super chat. Thank you for Randy. I'm going to answer Randy's question. Randy says, I'm currently under DACA. Should I file an I-130 in anticipation for Biden's parole in place? If PIP does not go into the law, do I still have to proceed with the I-130 process? So, Randy, with your so nothing you can still do an I-130 at any point, right? Regardless of whether PIP is on the table or not. But if PIP is not on the table, that I-130 really isn't going to get you anywhere, because you won't be able to adjust your status if you entered without inspection, or you were brought here and you don't have inspection records to show the government, which is why perhaps you have DACA, right? So what I would say to you in this situation is, well, I would have a little faith regarding PIP, okay? Have a little faith regarding that. As soon as PIP application process is opened up at the end of the summer, as the government has promised, then I would go ahead and do the PIP application process. After you get your PIP approved, then you should transition into the adjustment of status process with the I-130, I-485 together, and do your adjustment of status at that point. Okay, that's how I would approach it. Thank you for that question and for your super chat. All right. Let's see. When you put in your super chat request, friends, be sure to, if you have a question, add your question to it. Okay, I see some super chats coming in. I just see the money coming in, but I do not see any question attached to your super chat. So be sure to add that as well. But thank you, Sarah, for your super chat, and Leo for your super chat funds. Um, Thank you. Okay, so let's keep going, guys. Valente is asking, I'm really enjoying these PIP questions about, can I use my question I got, I think earlier this week, was about using the metadata that's attached to photos on social media or something like that as proof that I've been in the country for 10 years or something like that. Seems like this is another one. Does data from Google Maps history location work as proof of continuously staying in the US? Freedom Now. Thank you for that question. I'm not sure. Honestly, I've never seen a document checklist from USCIS that says that you could use things like that. I would say, look at the instructions for the PIP that's in place right now for military family members. Look at, I would say, any humanitarian process, maybe like TPS. TPS is a good one, I think, because you'd have to prove that you were in the country by a certain cutoff date. Look at those instructions by USCIS to see what they consider to be good proof of continuous residency here in the United States. But good question, okay? Freedom Now. Thank you for that. Let's see. What would be, because Kasanya is asking, what would be the best advice for a person that filed for her husband and stepson to come to the US, and USCIS has said that the child's birth certificate was invalid because it wasn't given at birth? That does come up when the birth certificate is issued late in life. For some people, it's at when they're an adult, they actually had gotten the birth certificate. What I could say in this situation is that um, there are some secondary evidence that you can also include with the case to prove the authenticity of that relationship, the biological parent child relationship, but also um, if you've gotten an RFE about that, yeah, you'll need to get that, you need to explain in that RFE through secondary evidence connecting that parent to that child, that that is in fact the child. We've had cases like this actually that involves typically the adults who had received a late issued birth certificate, and USCIS called into question the parent-child relationship. And in some of those cases, DNA evidence was also a very big part of the case. In addition to in addition to maybe affidavits from people who were around at the time of the birth who could attest that that is in fact the parent. There are some secondary evidence that could be included. Get an appointment with us if you had not yet submitted that RFE, if it is an RFE, so that we could look at this and evaluate it and let you know how you can proceed with this case, okay? Freedom Now. Thank you for that question. Let's see. Thank you. Thank you, Freedom Now. Freedom Now. Thank you for the super chats coming in. Let's see. Sarah's question is, my spouse has been in the US illegally for 30 years. Two illegal entry, one in 1993 and the second in 1998. Will he qualify for Biden's PIP? I'm not, Sarah, will he qualify? Um, the permanent bar, right? The permanent bar is something that attorneys are still debating. Okay, still debating that. I don't even know. There could be your husband could be barred permanently. I don't know with much certainty yet without looking at the record to confirm the dates, those years. I believe you when you say, 98 being the second unlawful entry and all of that. But if he is barred permanently, he would have to spend 10 full years outside of the United States before he's able to get a green card. With respect to the PIP, some of us some of us attorneys, me, myself included, and I've said this a number of times publicly, even though I know that other attorneys have said publicly the opposite, some of us attorneys think that in order to be eligible for PIP, one has to otherwise be eligible for adjustment of status. And if you're otherwise eligible for adjustment of status, then you could do PIP. However, because we don't have the clear instructions or guidance yet from the government, we don't know who is correct about this. We don't know if your husband will be eligible for PIP yet or not. It's case by case, it's discretionary. And when it's like that, case by case discretionary, we will have to talk about his immigration history. His immigration history does matter to a case by case discretionary evaluation that the government will be doing under PIP. So, depending on what else is on his record, if there's anything else on his record, he may not be eligible for this, but it's inconclusive right now about permanent bar, not until the instructions are released, okay? The guidance, the Federal Register. Thank you for that. Freedom Now. Freedom Now. Did I answer this one? Let's see. Hold on a second. Thank you for all of your super chats. Let's get this one up on the screen. Someone says that the C1D visa, been here for 11 years, married with a US citizen. I don't want to do the waiver. I'm scared to stay there. Doesn't want to go home. I'm scared to go home. Is there any way to do it from here and not have to leave? So with this entry, there is a bar to adjustment of status, and you know that already, based on how you entered with that particular visa. And PIP, the parole in place process, does not help you because you did enter with that visa and you were inspected. Okay, so PIP is off the table. You will need to do that waiver, the 601A, not unless you qualify for a green card under a different process, like the U visa case, U visa process for crime victims. Then you can get it done here, but the lawful status here in the United States. But with that C1D, you're going to have to do a waiver and go back and interview at the U.S. Embassy, okay, because of the bar to adjusting your status. Thank you. Let's see, here's another one, another super chat. Thank you for your super chat. Okay, I think yeah, that's the one that I just answered, right? Yep, the C1D visa. Um, let's see, here's another one. Okay. Okay, so hello, I have DACA. I'm not, did I talk? Okay, I have DACA and I'm not married. I'm divorced. I was wondering if I could adjust my status even though me and my parents overstayed our visa, plus I'm engaged. Could my wife file? Okay, so you mean your fiance, right? Because you're divorced, you're not married yet, you're engaged to be married. So if you did get married and PIP is not something that you would be eligible for. You probably already know that because you were not married to a US citizen by the cutoff date of June 18th, 2024. So you would need to do it the way that it's currently being done, which is you will need a waiver and then you'll have to go back and interview at the US Embassy. Okay, you have DACA. um, you'll need to, so here's the thing. If you, for DACA holders, um, okay, so you have DACA, the question is, do you have any lawful entry on your record? Did you ever get advanced parole through DACA and leave the country and come back? Because if you have that on your record, that I-94 on your record, and then you're married to a US citizen, you wouldn't have to leave the country to finish the process. You could get your green card here through adjustment of status. And we have a testimony about how we've helped a DACA holder recently in that type of situation. If you do not have that lawful entry on your record over the years, then you will not be able to do adjustment of status. You will need the waiver, the 601A, and then you'll have to go back. Not unless you eventually get advanced parole and you leave and you come back in, then you could do adjustment of status through your new US citizen wife, not PIP, however, okay? You guys are asking some great questions today. Thank you so much. Freedom Now, Freedom Now. Happy 4th to those who are coming in. And do I have sound? Is my sound? I still have sound. I see that Kiona is asking about sound. Can you guys hear me? If you could hear me, give me some, some likes. Let me know that I'm still good on the audio part. Can you guys hear me? Let me know, guys. Is my audio still good? Freedom Now. Let me know, guys. Is the audio still good? Yes? Freedom now, freedom now, freedom now. Sound is good. It's good. Okay, thank you very much. I see your comments now. Sound is good. Okay, perfect. Thank you. Freedom now. Freedom now. Okay, I've answered that one. Okay, here's another super chat. I have a fiance. If I marry her, can she help me to adjust my status? Can she file for me? I have never been convicted of a crime. I have a clean record, clean BCI. So, uh, we would want to know a little bit more about your immigration case because from the facts that you've mentioned, it sounds like certainly she could file for you if she's eligible as a petitioner. She could file for you, but whether you could adjust your status or not will depend on is she a U.S. citizen? Okay, you say you have a fiance. If I marry her, can she file for me and I do adjustment of status? So U.S. citizen spouse, yes, you can do adjustment of status through her if she only has a green card. No, if you have overstayed, I don't know how long you've been in America. I just know that you have a clean criminal record. Great, but to adjust your status, it takes more than that. Okay, how did you come to the United States? Do you have an I-94 record? Were you ever inspected and admitted or paroled into the country, a certain type of parole? Those are the things that matter for adjustment of status. So once you guys marry and you're ready to move forward with the filing, get a consultation so that we could evaluate your background and let you know whether you could adjust your status or not. Freedom now, freedom now, freedom now. I'm getting a lot of super chats today, so that's why I'm going to them. Sorry, guys. Once the super chats calm down, I'll come back to those who have not engaged in that way. Question is, I filed my I-751 petition in January 2024. Then I did VAWA last month. What should I do, please? So when you filed the I-751 in January, just 7 months ago, right? Did you do it jointly with your spouse or did you do it on your own, alleging that the marriage is over, it ended in divorce, or it ended because of abuse, or it's over and because you suffered extreme hardship over the last couple of years? How did you file it? If you did file it jointly, not a big deal because things happen. And even after that jointly filed petition, things can go wrong in the relationship, and then you have to pick up the pieces and try on your own. The VAWA case, you filed for VAWA indicating that you have suffered domestic abuse in this marriage. The USCIS is going to be looking at both of those. I don't know if you had withdrawn what you've done with the I-751. Hopefully it wasn't withdrawn. Hopefully what you did was you submitted an I-751 waiver based on domestic violence abuse. So contact us for an appointment because I would really be curious to know if you did both of those if it's truly a VAWA filing or if it was a domestic violence argument, I-751 conversion case into a waiver. So contact us so that we could go deeper with you and unpack things, okay? Because it sounds like you have a lot going on there. All right. Freedom now. Thank you for the super chat, however. Thank you. Raise your hand, Ms. McBean. You're doing a good job. Appreciate you. Blessings. Thank you for that. I appreciate that. Thank you. And guys, I'm going to have to wrap up momentarily because I do want to jump on TikTok as well and Facebook. Someone says, I entered the United States illegally recently. What's the next step in getting my stay here Is it a guarantee? So entering the United States illegally presents a lot of problems. Okay, I'm not even going to sugarcoat this one. It presents a lot of problems to obtain a lawful status, and folks think sometimes that they could come to the U.S. and apply for asylum, get a work permit and a social, and then they're going to get a green card. It really doesn't happen that way. And then others think, well, if I marry someone after coming in illegally, then it's all good. No, it's not either. And most of those individuals cannot get a green card even through a U.S. citizen spouse because the entry is considered illegal. And that's the biggest problem, the illegal entry. So, what happens is most folks apply for asylum because that's it. They don't have anything else. So, they have to apply for asylum. But unfortunately, most of those cases are frivolous. They are based on economic needs or they're based on crime in their country and not really no merit. There's no merit to the case. So it's hard for me to tell you what to do at this stage other than to say I don't think you should apply for asylum because if you don't have an asylum case, don't do it. I know it's going to be tempting to do that because you'll want a work permit and a social security card, but just know that the wrong asylum case can lead to more trouble, specifically a removal order. Okay. And if you are most likely you're in immigration court, you're in removal proceedings. They have been directing people to go to an ICE office and check in upon, in the city that you're destined to go to. So you definitely want to follow the protocols of checking in with ICE, and they'll give you more instructions like a notice to appear in court. You should definitely appear at every hearing. You should get an attorney to represent you in immigration court proceedings. Okay, so these are the things that you should actually do and follow. And then the attorney will take it from there as it relates to whether you should apply for asylum or not. But again, only do asylum if you're eligible. And if the attorney says, I don't think you're eligible, well, most people, what they do, they go find an attorney who says, I don't care if you're eligible or not, I'm still going to do it because I want your money. You will always find that. That will always, always, always be available to individuals, despite the fact that you're not even eligible for asylum. So be very careful, okay? Freedom now, freedom now. Um, Someone said, and then I've got to jump off, guys. This is great. We're a little bit over an hour. I know someone writing for advanced parole, waiting for advanced parole, but wrote on the paper that she's going to Jamaica to a funeral, but in reality, she's going to Cayman. Why are you Eric? Why are you putting this person's business out there? She's actually not going to a funeral. She's going to a wedding in Cayman Islands. Will that be an issue? Um, so, you know, you're not the individual, whoever that individual is, they lied. That's their prerogative, right? It has nothing to do with you or me. Um, I don't necessarily think it's going to be a big problem. But have that person contact us if in fact they do get in trouble for that. I don't think they will though. I don't really see that as any big like a huge issue. Okay. um okay, this is the last one I'm answering from the super chats. Does having a visa then overstaying mean you still possess lawful entry? Yes, you have, as long as you were inspected and someone said, come on in, okay, in a uniform, right? That said, come on in. That's inspection and lawful entry. I was issued a social security card. I came here legally. I still have DACA. Okay, so you should be able to adjust your status then, piggybacking on your earlier question. You should be able to adjust your status through that US citizen spouse, okay? Because you have your entry, which is great. All right. If you need any help with that marriage case, we're here for you. Come back in. Guys, Eric, too much information. Okay, I just saw your last comment. Guys, you've got to use some discretion. Eric, delete your comment, okay? You put out too much information. Don't do that. Use discretion, okay? This, you guys aren't the only one watching my channel, okay? You're not. Eric retracted. Very good, Eric. Um, guys, it was so nice spending this afternoon, this 4th of July with you. Our office is closed, but our receptionist team are still available. They're on standby today. They will be booking appointments, so contact us at 888-462-4006 to book an appointment with McBean Law. Thank you guys so much for trusting us over the years. Thank you for your faithfulness. Thank you for subscribing to this channel. Guys, have a wonderful and safe 4th of July evening, and I will see you tomorrow evening between 5 p.m. and 6:30 p.m. Eastern for our immigration news discussion about U.S. Supreme Court decisions that will impact immigration. Thanks so much, guys, and I will see you soon. Bye-bye.